So this is a guidelines reduction that you've probably never heard of that may be worthwhile for you to look into to see if it applies to you to then get lower guidelines. And this is called a minor participant reduction or a minimal participant reduction. This is codified in United States Sentencing Guidelines 3B 1.2. Under this guideline, you can get between 2 points and 4 points off if your culpability in the case is less than that of an average participant. And whether you get 2 points off or 3 points off or 4 points off really depends on the comparison of culpability levels on the particular case. So it's something that your attorney should look into. The burden of proof that you have to get this minor participant reduction is by a preponderance, meaning your attorney has to show by 51% or more that this applies to you. And depending on where you are in the sentencing chart, these 2, 3, or 4 points could really make a very big difference on what your applicable guidelines are. I'm not telling you that the prosecutor will give it to you. You always ask and then you see what happens. But ultimately, if the prosecutor is not willing to include these points in the plea agreement, what you may be able to do is negotiate what's called a carve-out, which is when in the plea agreement it says the parties do not have an agreement as to whether or not this minor participant or minimal participant reduction applies, but we want to do a hearing before the judge at sentencing for the judge to decide if this applies. So if you're in a big case, if there's other co-defendants, and if your role was truly much less than that of your co-defendants, that may be something that you and your attorney look into just to pick up those extra points to move your guidelines down on the chart.